Thank you very much. Let me thank the witnesses for a very helpful hearing. I'll make a brief closing statement, if I may, to follow up on what Senator Kaine has said. Senator Kaine is a very able lawyer. I've got to get down to judiciary. Senator Kaine is a very able lawyer, and one of the key features or subtopics, if you will, of this hearing has been the problem of conflicts of interest and how to explore conflicts of interest. Exploring conflicts of interest is how you distinguish in part between a simple difference of opinion and motivated opinion that is paid for and is perhaps not even sincerely held. And I think it's important to recognize the importance of bias and conflict of interest when you're dealing with testimony, whether it's in Congress or whether it's in courtrooms. As Senator Kennedy just said, it has to do with your credibility. And it's important that that be disclosed, because the difference between paid for opinion and real research is a very important thing. Mr. Pilkey has been quite good about this. If I may quote from a Substack, experts monetizing their expert is one important reason why people become experts. But where expertise and financial interests intersect, things can get complicated. That is why there are robust mechanisms in place for the disclosure and mitigation of financial conflicts of interest. All of this is just common sense. Your doctor can't prescribe you drugs from a company that pays him fees. You wouldn't think much of a report on smoking and health from a researcher supported by the tobacco industry. And because we're both lawyers, we also have spent some time in courtrooms. And one thing I can tell my colleagues about a courtroom is that when you have a witness, particularly when you have an expert witness, one of the things you explore in your cross-examination of that witness is their bias, is their conflicts of interest. It is so normal in courtrooms to challenge witnesses on how they're paid and who is paying them that it would be error for a court to refuse to allow the lawyer to conduct that examination. It is as established a principle of trial practice as exists. So let's appreciate that if it's essential in a courtroom for a jury and a judge to be able to test the credibility of a witness by having their conflicts of interest made a matter of record for the judge and jury to see, it is also appropriate for other hearings as well. So with that, Mark, thank you, Mr. Pilkey. I see you nodding. You want to make your own?
A minute, me and Johnson.
You want to offer?
A minute?
I'll give
one minute for me?
Of course.
Okay.